Hello and welcome. Welcome to Raising Money Through the Jobs Act, Regulation A+. I'm delighted to have you join me for this special webinar and have an opportunity to talk to you about some exciting real developments that have been occurring in the securities business. My name is Larry Pino. I am the founding partner of a law firm in Orlando, Florida called Pino Nicholson. We specialize in commercial law. In I suppose, general terms, but specialized in various aspects of commercial law, commercial litigation, with a particular concentration in securities work. We do offerings for clients, obviously in Florida, but pretty much across the country. And we focus not only on their legal work, but also with respect to assisting them in structuring the type of business model that they're looking to achieve based upon what their business objectives and investment objectives actually are. This particular webinar is going to be focused on Reg A, and you'll get very clearly why it is something that individual investors and business people today certainly want an opportunity to be able to at least understand. The agenda for the conversation that we're going to be having is on the screen at this point. I want to talk about the Jobs Act itself, how it happened, where it came from, and all that. We're going to talk about the law on Regulation A, the opportunity available, the advantages associated with Reg A, and then talk a little bit about structuring it so that you have a better understanding of how these things get structured, and based on that, the benefits that you have an opportunity to receive. In doing that, by the way, the webinar is certainly going to be under 30 minutes, and I'll do my very best to be as efficient as I can, because as you can imagine, as a lawyer, I can talk for a very long time. Let's talk a little bit about the Jobs Act, where it came from. I'm sure that you have a very vivid recollection of those dark times called the Great Recession in America. And at that time, everybody was extremely focused on what to do to jumpstart our economy. And recognizing that startups, small businesses, small investors, and so forth, had the best opportunity to be able to really get the economy moving again. Congress and the President were looking for a way to be able to institutionalize, to legislate some modifications to the securities laws in order to allow small business people greater access to the capital markets, because you can only do so much unless you have investment dollars to do it with. And their attempt was to figure out how they could modernize somewhat the very complex securities laws in a way which would allow these small investors or small groups of people to be able to do that. They eventually ended up passing a law called the Jobs Act in April of 2012. With that law, however, it was required to go to the SEC in order to have the rules and regulations so that everybody understood how it actually was going to operate get passed by the SEC. SEC did their job with respect to two important modifications. One was what's known as a Regulation 506C, and that's the subject of another webinar, which is on my law firm website, by the way, that you could certainly listen to at your convenience. But this particular one on Regulation A also got passed. In 506C, those rules were promulgated and ultimately became effective on October 23rd of 2013, and the Reg A rules and regs became effective as of June 19th of just this year, 2015. So as a result of that, we now have access to the updated Reg A rules that really have been tremendous at assisting small businesses and investors to have access to the capital markets. Now, let's take a look at each one of those, and then you'll get a better idea of how these can be beneficial to you. The first of the Reg A offerings relates to what's known as Tier 1. The big difference between them, there are a couple of differences, but the big difference between them is strictly the amount that you can raise in Tier 1 versus what is Tier 2. With respect to Tier 1, it cannot exceed more than a $20 million offering amount in a 12-month period of time. So obviously, if you need to raise $25 or $30 or $35 million, Tier 1 isn't going to work, but Tier 2 will, and we'll talk about that. unlike exempt offerings, and if you're familiar with exempt offerings, you know that you don't have to file anything with the SEC. You don't have to file anything on a state level, at least not for a 506B or a Rule 506C. In this particular one with a Reg A, there is an actual filing, and the filing is going to be with the SEC in Washington. You file a Form 1A, and that's the form, by the way, that's right there on the website. In other words, you're going to actually be filling out the information on the SEC's website. It's called a Form 1A, and you put all that information on an online basis. You don't even have to, in the old days, you know, we had to send these things through snail mail, if you will, to the SEC or get it hand-delivered or FedExed and so forth, but now it's 100% being done directly online. When I talk about that third bullet point, you can test the waters, but you can't accept any funds until it's been reviewed and qualified by the SEC. What I mean by that is you can put an offering together, and you might be thinking to yourself, gee, I don't know if any investors are going to be interested in this particular investment opportunity. You can put it together, and you can go out there and you can test the waters even before you have SEC approval. Because, you know, if you had to have SEC approval first, by the time you've gone through that entire process, you know, you've done the yeoman's effort in that context. So you can actually put the offer together, you can actually send it in, but you can test the waters. The only thing you can't do, though, is you can't actually have anybody give you any investment dollars until the SEC has signed off on your particular offering. There is no limit to the amount of investors that you're allowed to have, and in addition to that, there is no limit to the type of investor. So, for example, it doesn't have to be an accredited investor or, you know, a sophisticated investor or anything of that nature. And I'll talk a little bit more about that when we talk about Tier 2. You do not require an audited financial statement in a Tier 1. And so as a result of that, for the first 2 years in any event, you can just simply have unaudited balance sheet income statements during that 2-year period of time. After that, you are going to be required to have an audited statement. And you must, with a Tier 1, comply with state blue sky, which means that while you file with the SEC, if you are in a filing state for Tier 1, you are going to have to file with that particular state. Now, with that, and I'm going to get a little bit clearer with respect to these, but I want to talk about Tier 2 first. A Tier 2 is a Reg Plus offering, and what that does is it allows you to go not to $20 million, but it allows you to go up to $50 million in a 12-month period of time. It's the same exact form. It's a Form 1A, which gets filed with the SEC. Same exact rule with respect to testing of the waters. Now, here's where the good stuff comes in, if you will. It allows you, by virtue of the fact that it is an actual filing, you do have the right, and you have the right whether it's Tier 1 or Tier 2, to be able to publicly solicit. In other words, you can market, you can send out direct mail, you can put advertisements in newspapers, you can put them in classified ads in the Wall Street Journal or the local edition of the Wall Street Journal or Investors Business Daily or whatever publications would be appropriate for the type of investment that you're putting together. So you can publicly solicit. Number 2, you don't have to have a prior relationship with the person who is investing in your particular offering. Number 3, that person does not have to be an accredited investor in order to be able to invest in your Reg A. However, the only limitation, and if you'll notice that in my 4th bullet point, the only limitation is that an investor cannot invest, and I should say this, a non-accredited investor cannot invest more than 10% of their income or assets, as the case may be. So if they have income of $200,000 a year, they can't invest more than $20,000 if they're not accredited. Or if they have assets of $200,000, they can't invest more than $20,000 in your particular investment. So it's an investment limitation of 10% if they are not accredited. If they are accredited, then they do have the opportunity, and I'll talk about what an accredited investor is in just a second. They can exceed that 10% limit in most states, although there are a couple that you would not want to do. There's no restriction on the resale of the securities because remember, unlike an exempt offering, a Reg A is an actual public offering, and so to that extent, there's no restriction with respect to the resale of these securities. As a matter of fact, if you take a look at some of these over-the-counter markets, you actually can see Reg A securities that are actually listed in those. You do have to have an audited financial statement in order to begin, and the audit is simply, by the way, whatever your initial balance is, and then you're going to be providing audits from that point on. Finally, unlike Tier 1, which is not exempt from state blue sky, Tier 2 is exempt from blue sky, which means is exempt from state regulation, and by regulation I'm talking about the filing and the approval by a state securities commission, although there is a notice filing. And what that simply means is that you would have to identify for a state that has a notice filing requirement that this thing exists and this thing has in fact been filed with the SEC. In Florida, by the way, there is no notice requirement in the state of Florida. I mentioned to you that accredited investors did not have the 10% limitation. Let me tell you what an accredited investor is. An accredited investor is somebody, there are two tests. One is an asset test. So an accredited investor is somebody who has $1 million of assets, excluding their personal residence, or an income test, which means that for the prior 2 years, they have earned more than $200,000 on their individual income tax return, or jointly $300,000, and has a reasonable expectation of making that same amount of money this year. If somebody is an accredited investor, there is no investment limitation to how much they can invest, and in addition to that, they have the opportunity to be investing in a Reg A. Now, unlike other exempt offerings, and certainly unlike a 506C, which is the subject of another webinar that I discussed, what is notable is the fact that there is no verification requirement for a Reg A. Now, you do have the qualification to make sure that on a non-accredited basis, you're not obtaining an investment of more than 10%. However, in terms of the accreditation of that investor, there is actually no requirement that there be verification, which is a major advantage that a Reg A has over a 506C. So with that said, let's take a look. What are the advantages of a Reg A offering? Well, the first thing is it's a public solicitation. So unlike the exempt offerings like a Rule 506B and other types of exempt offerings, like an intrastate offering and so forth, that don't allow you to publicly solicit, in a Reg A, you can publicly solicit. So as I mentioned, all of the different ways that you can think about marketing, like, for example, putting up a website, driving people to your website, doing an event in a venue that would that you could use to invite investors in, and I'm sure you've seen some of them. You see investment seminars at a Ruth's Chris restaurant or a Morton Steakhouse or any number of locations. You could actually use that type of event to be able to market a Reg A fund. You do not need to have any prior relationship with the investor. You could have met them for the very first time when they called you because they saw your classified ad in a newspaper. It is not limited to accredited investors, as a 506C is, which is the other type of offering that allows public solicitation. In this case, it's not limited. It could be an accredited or a non-accredited investor. There is no requirement for any type of verification attached to the accredited investor status. You can have your own dedicated website. You can be included in other websites. So for example, you've seen these crowdfunding websites that are all over the internet today. You can include your Reg A in those types of websites also. The bottom line is, with it, you can actually, what I call, routinize the capital raising function, which allows you to have a more efficient way of raising capital. So with that said, and again, I'll go back to the benefits in a second, but let's just talk a little bit about how you structure these particular offerings. Very typically, what I will use almost all the time is a limited liability company. There have been a couple of occasions in some states that I've used a corporation. But because of the advances that limited liability companies have made, both at common law and on a statutory basis in most states, and certainly Florida is sort of right at the very top of those, limited liability companies have lots of advantages over corporations in lots of different ways. So the way that I will tend to structure it is I usually use two different companies. I'll use a limited liability company as being the actual offering entity. That's the one that actually raises the money, and it's the one that actually deploys the capital for whatever the asset is that this company is going to be investing in, or the business that this company is going to be doing. So that's the first, and that's the first limited liability company. Secondly, I almost always will use a manager that is a separate limited liability company. So the limited liability company is the one that raises the money, and the manager is the one that manages that company. And so I will use as a structure two different limited liability companies, and of course I give each of them an operating agreement, both for the fund or the company and for the fund manager or the company manager. On the business level, you have all of the, the normal things that you would ordinarily have for a business. Obviously, you would want to have a website. You would want to have the technology platform. Let me tell you what I mean by that. The advantage of a Reg A is the fact that you could actually use the website to solicit individuals. So not only is the company recognizing whatever it does to either as an investment or as a business, but on top of that, if you also had a tab, and that tab says for information on investing, and somebody could click on that tab, you would actually have the ability to be able to use that website from a tech standpoint to actually have the documents downloaded directly to the individual who would be interested in investing. And that's certainly a service that we have provided for our clients when it became appropriate. In addition to that, you can either have a home office, obviously, or a regular office if you're working out of an office, and then the typical type of stationery and business cards that you would ordinarily have. So from a structural and a business standpoint, that's pretty much what you need. Let's talk a little bit about the securities documentation itself. A Reg A will typically have, number one, the offering circular. And I know that some of you who are listening on this webinar are familiar with what's known as a PPM or a private placement memorandum. When it comes to a Reg A, that PPM is called an offering circular. So the Form 1A that gets filed with the SEC is actually known as an offering circular. That's the document that's got all of the detail about here's how much I'm supposed to be investing, here's what I'm going to get out of that, here's my rate of return, here's how I share profits, and so forth and so on. That's in the offering circular. In addition to that is the subscription agreement. Once you have given the offering circular to somebody, there's a subscription agreement attached to it. That's what you're going to have them fill out. And by filling it out, what I mean is they're going to identify, they're going to invest $10,000, depending upon how much your minimum is. Your minimum could be $25 a share or $25 a unit if it's a limited liability company, or it could be $5,000 or $2,500 minimum. The subscription agreement, you put down or the investor puts down how much he or she is going to be investing, and then some information about the investor, and then they sign off on that subscription agreement, and that's what gets given to you. Investor qualification profile is the document that says, well, I am accredited, or no, I am not accredited, but my income and my assets are as follows. Now, What's interesting about that, by the way, is that you don't need verification. These are self-verifying. What that means is it is sufficient that they have told you that they are accredited. It is sufficient that they've told you what their income and assets are if they're not accredited, and you don't have to verify that as you do under, for example, a Rule 506C, which does require verification from accredited investors. Certificate of ownership, if they're buying stock or they're investing for units, whatever that certificate is, and you have a nice parchment security document that you just simply buy from providers that provide that, and you send them that certificate of ownership. So like the old days when somebody would actually get a stock certificate in General Electric or IBM back in the good days when people would actually take those certificates and hold on to them before the electronics. Well, nowadays I certainly love and always recommend the use of an actual parchment certificate of ownership that you get sent to your investor so that they have that feeling of ownership in this particular investment. That obviously assumes that you're going to have transmittal letters. Enclosed, please find. I'm delighted that you're on board, and we're all looking forward to doing this together. I always include, by the way, a memorandum of instruction. Regardless of how experienced and my clients go all the way from the first-timers who are doing this for the first time to somebody who is a seasoned investor and a seasoned promoter. But I always include a memorandum of instruction that says, here's what you should be doing, here's what you should not be doing, here's how often you should be communicating with your investors, here are some of the subject areas that you would want to be talking about with your investors, and so forth. And then you do have to have a marketing review prior to submission to the SEC. The SEC is going to want to see what marketing materials you're using, and so that comes as part of the securities documentation. When it comes to the filing itself, we prepare the documents for filing. We then go ahead and file, of course. SEC ends up coming back with requests and inquiries and questions, and you respond to those as is appropriate. And then you make revisions to the documents that are requested by the SEC until such time as everything is completed, and then you're good to go. So, real briefly, what do you need to do? You need to structure the companies. There are usually 2 companies at least, sometimes even more than that, but you structure the companies. Number 2, you prepare the securities documentation. And then, of course, number 3, you file them with the SEC, and then you continue to deal with the SEC until you have your final sign-off on behalf of the SEC. Now, what does all that do, and what can you then go about in terms of your business opportunity? So what it looks like, and the reason I say focused opportunities, is because you really want, your Reg A is not just simply, I want to raise money to do what I want to do. You really want to be focusing the opportunity in a particular area. So it could be distressed assets as a general asset class, but then again, it could be very specifically distressed assets that relate to, for example, foreclosure homes, or it could be foreclosed homes in the states of Michigan, Indiana, and Illinois. It could be distressed asset categories could be in, for example, industrial buildings that need to be fixed up and are distressed because they've just simply, because of wear and tear, have not been redeployed in current commerce. General forms of real estate, and of course they're just massive different categories. Real estate, office buildings, for example, commercial strip centers, old C properties that are shopping centers but have not been renovated in years, all the way to pristine blue ribbon properties of any nature. Mortgages. I'm doing one right now, for example, for an individual who is going to be involved in second mortgages and wants to have an offering specifically related to investors who are interested in investing in second mortgages that are primarily privately held second mortgages. We've done a number of them in the assisted living facilities, which, as you can only imagine in senior housing today, with the tidal wave of seniors that are approaching the marketplace, assisted living is a very popular investment and asset category. Technology companies, all the way from trading software to for the securities markets to software for origination of mortgages, to all kinds of different tech plays. Businesses themselves, private equity for investments, and on and on. The bottom line is a Reg A can be used for any opportunity that you can think of. I've done any number and I've done in oil and gas, for example, although the structure is a little bit different than what I just described in oil and gas, but obviously very prevalent in terms of investment opportunity. Your flexibility of investments means that what you are doing once you have your Reg A done is that you can either do a direct investment in the asset class that you're planning on investing in, or you can find other types of companies or funds that are investing in that asset class, and you can invest in their fund. And you can take an arbitrage between the two, or if you will, a spread between the two, so that they're managing the assets, you're bringing in your investment dollars, and you just simply have a spread of a couple percentage points that actually go to you for that reason. In addition to that, you could, of course, provide for management fees for yourself, the income that comes from your fund, and in many instances, particularly because I use an LLC structure, you also have tax benefits attached to that. Now, I promised you that I would keep you under 30 minutes, and that's about as much time as I can do without going over. But let me just simply suggest, I know that you probably have a number of questions that you have for me and for certainly about this entire category. I want to just suggest to you that if you'd like more information or if you have specific questions, by all means, give us a call. On the screen is Kathy Simmons. She's my personal assistant. She's been my personal assistant for 35 years. So I think she knows how to get a hold of me. Just simply feel free to call in. Obviously, the initial consultation is absolutely free. Be glad to answer any questions that you've got. And certainly I can review what fee structures look like and things of that nature at this time. So with that said, let me just simply suggest that Reg A, as a result of the Jobs Act, has been a tremendous boon, along with other improvements, by the way, and modifications to some of the actions, have been really just a tremendous opportunity for investors to go out and investment groups to go out and put money together to be able to pursue opportunities. If you think that Reg A might be something down your alley, by all means call me and I'll be glad to meet with you, talk to you, and answer any questions that you've got. Thank you so much for participating in our webinar, and I hope to hear from you at some future time.